I'm Lisa Shepard, and I am the Executive Director of the Chief Justice's Commission on Professionalism. The mission of the CJCP is to enhance professionalism among North Carolina lawyers, judges, and law students, a mission which it has been doing since 1998. One of the ways that the CJCP does this is to sponsor this historical video series, which is a collection of video interviews of distinguished lawyers, judges, and professionals from across North Carolina. The CJCP began filming these video interviews in 2000 as a means to preserve the thoughts of these bar leaders on the legal profession and on professionalism issues. All of the videos in this series are available to you on the CJCP website and the CJCP's dedicated YouTube channel. We are so fortunate to have had many distinguished members of the North Carolina Bar over the years, and they have much accumulated wisdom to share with us. It is important to understand that the practice of law is a profession, and doing it well requires not only substantive knowledge that one gains in law school and from studying for the bar exam, but also the value of experience learned from other lawyers. I hope that this video series will give you not only a fresh insight into the person being interviewed, but also some meaningful information about how to be a better lawyer in your own practice. Enjoy, and remember, esse quam videri. Strive to be professional in all that you do, rather than to merely seem so.
The Chief Justice's Commission on Professionalism was established in September of 1998. One of its programs and its most important mission is the enhancement of professionalism. The Chief Justice's Commission on Professionalism's historical video series is designed to interview some of the most distinguished lawyers in North Carolina. Today we have the privilege of interviewing Walter F. Brinkley. Mr. Brinkley was born in 1926 and raised in Lexington, North Carolina. One of America's greatest generation, he served in the United States Navy from 1943 through 1946 during World War II and at its conclusion, and again during the Korean conflict from 1951 through 1953 with the rank of lieutenant commander. He achieved his law degree from the University of North Carolina in 1949 and was licensed to practice law the same year. He began his career as a lawyer as a staff attorney in the office of the Attorney General of the state of North Carolina, serving in that capacity from 1949 through 1951. Upon returning from Korea to practice law in Lexington, he started with the firm of Don Waltzer, and today is known as Brinkley Waltzer PLLC. Mr. Brinkley has led a distinguished career. He has been active in the profession, serving as president of the North Carolina Bar Association from 1974 through 1975. Mr. Brinkley was one of the founders of North Carolina Legal Services Corporation, Inc. He also served on the Board of Law Examiners and chaired that committee. Mr. Brinkley has led a distinguished career and is recognized as being one of North Carolina's preeminent lawyers. He is listed in Best Lawyers of America. He is a fellow of the American Academy of Trial Lawyers and the International Academy of Trial Lawyers. He has received numerous honors, including being selected to the North Carolina General Practices Hall of Fame, and he has also received the North Carolina Bar Association's most distinguished honor, that of the John J. Parker Award. My name is Hank Van Hoy. I'm a member of the Commission, and it is my privilege to interview Mr. Walter Brinkley. Mr. Brinkley, if you would, we were talking this morning about what it means to be a lawyer in North Carolina and what a privilege it is. Tell us your views about that.
Well, I've always had the view that a license to practice law in North Carolina was not actually a license. Actually, it should be considered a privilege because the members of the North Carolina Bar are really operating as a monopoly in some respects. We are protected from competition and given the opportunity to serve in that capacity. And because of that, I think the members of the bar have a duty to repay the public by offering public service in various forms. And lawyers are particularly equipped to offer that service in areas of government, in areas of civic endeavor, and in other areas where their training provides them with the resources to contribute.
Do you think that lawyers today are fulfilling that obligation to the extent that, in your view, they should?
I don't want to be critical of the bar as a whole or of any particular lawyer, but I think over the years, the participation of lawyers in public service has deteriorated to a significant extent, and I think that more emphasis needs to be put on that aspect of their overall practice.
Well, let's come back to that in a moment and talk now about your early life, the things that led you to become a lawyer. You were born on the cusp of the Great Depression and the son of a lawyer. Tell us about the early experiences of living in Lexington, North Carolina.
Well, I grew up in Lexington, a small town, a population of about 10,000 back then. The middle of the Depression, which had had a significant effect on the life of practically everyone. My father was a small town lawyer. I had the highest respect for him, thought he was the best lawyer there was and still do. But it was a great experience because we had the camaraderie of that really comes when living in a small community where everyone knows everybody else. And during a time of economic depression, I think people had more empathy for their friends and neighbors, and there was a more cohesive atmosphere than we find now.
Do you think those experiences affected your goals and your attitude about the practice of law and working together to solve problems?
I think they definitely did. I had the opportunity of being around my father's office from time to time and of hearing him at home discuss the problems that he had and the situations that existed among local people. And it gave me a feeling that a lawyer could actually be a very significant part of a community other than simply appearing in court or trying cases.
Was there a time in your youth when you felt that the course of following in your father's footsteps was open to you?
Yes, I had one experience that was particularly significant. When I was about 11 years old, this was 1937, the depths of the Depression, I remember one day my father came home to lunch, and after we'd finished, he asked me if I would like to ride over to Davie County with him. He was going to try a case there that afternoon. I didn't particularly want to go. I'd rather play baseball, but I did go and found myself in court with him. And he was representing a black tenant farmer who was accused of stealing his white neighbor's chickens. And I can still see that courtroom that was filled with white faces except for a few black faces up in the balcony. And all the officials were white, and all the jurors were white. And I thought about my father's task as he went about defending a black man under those circumstances. And I was so impressed with his dedication and determination that I decided right then that what I wanted to do was to be a lawyer.
How profound was the feeling of injustice that you felt from that trial and the circumstances of an all-white courtroom, all-white judges, personnel, and so forth.
Well, even at that tender age, I had the ability to see that the cards were stacked against that defendant. And that was, I think, the thing that impressed me the most, that my dad would go in against insurmountable odds and fight as vigorously as he did to try to bring about some justice to this defendant.
And as you served in the Navy during World War II and then went on to get your law degree in 1949, you began your career as a staff attorney with the North Carolina Attorney General's office. Tell us about that experience and how it benefited you.
Well, it was probably the best thing that happened to me as far as my legal career is concerned, because at a very early point, I was given the opportunity to participate in trials, in hearings, in a lot of other phases of the practice of law. And I was given the opportunity to become associated with, or at least have an opportunity to observe very closely some of the leading lawyers in North Carolina, and to be involved in some of the most important cases. For instance, the lawsuit against the University of North Carolina to desegregate its law school was started while I was there, and I had the opportunity to work as counsel in that case, all the way from the trial stage up through the final appeal to the Supreme Court of the United States. I was able to participate in probably 20 appeals of criminal cases to the Supreme Court of North Carolina. And as a result of that, I developed a confidence that the lawyers on the other side, regardless of their status or reputation, were really no better than I was with equal preparation. And that has helped me a great deal throughout my years of practice.
So from that experience, what advice would you give to young aspiring students in law school and young lawyers about what experiences they might seek to have earlier in their profession that would benefit them in their long-term careers?
Well, I don't think there's any one perfect track to follow, but I think there are a number of opportunities that young lawyers may take to have an association with experienced lawyers that will give them an opportunity to see what the profession is really like. For instance, there are lawyers who go to appellate judges as law clerks. There are many state jobs or positions in the Attorney General's office or other state agencies, or there are opportunities to join a firm as an apprentice. But any opportunity to become acquainted with the actual process before you venture out into the practice, I think is very helpful and very desirable.
When you were participating with some of these distinguished lawyers you named, McNeil Smith, Welsh Jordan, Grady Barnhill, and your own colleague Don Walter, what are some of the characteristics, skills, abilities, ethical standards that you saw in them that you thought were important to emulate?
Well, I don't think that, again, there's any standard. You can't classify the skills and expect everybody to have the same ones. But in each of those lawyers and the other outstanding lawyers that I've had an opportunity to know, there was first a very high degree of integrity, and that is almost an essential as a beginner. And then there was the innate intelligence that helped some of them. Now, I have a story that I like to tell about a meeting between Don Walser and Wells Jordan. Don was more of a plugger. He worked all the time, and he was not the most brilliant person in the world, but he was able to take things in and be prepared for hard work. Wells just seemed to have the innate ability to see the point at the beginning and come up with the right answer. And Wells said to Don, you know, Don, the difference in you and me is I've got a first-class mind that works sort of in third gear, and you've got a third-rate mind that works in high gear. So it illustrates the difference. And we can't all depend on the same qualities, but each lawyer, I think, who achieves success develops that success based on his own skills and abilities, and by preparing and getting the most out of what he has to begin with.
So I glean from your answer that to you, hard work, preparation, mastery of the law and the facts are fundamental keys to a lawyer's success in representing clients.
Absolutely, and probably the most important is preparation.
After you left the Attorney General's office and went back on active duty, you came back in the Navy, then you came back to your hometown in Lexington to begin the private practice of law. Tell us about these early years.
Well, they were, to say the least, a little bit difficult, as it would be for anyone who's starting in something that's relatively new. I had a very general practice. Our philosophy, I think, was that we would accept any client who walked through the door. We didn't always place prime importance on the ability of that client to compensate us. We tried to treat our clients as individuals and to rate the importance of their case not necessarily on the monetary amount involved, but with the recognition that every client has a right to the undivided attention of a lawyer to his case. I practiced in the field of criminal law, real estate, corporate law, wills, probate, throughout the whole spectrum. Later, I became involved in the field of education law, representing 2 school boards for over 30 years, and the practice changed to some extent. The trial aspect diminished in importance. When I first started, I was trying probably 2 or 3 cases a month on a regular basis. And now it seems that the actual trial of a case before a jury is somewhat a rarity. And the reason is there are many more pretrial aspects and more opportunities to resolve litigation by settlement. And that's a good thing, but it is simply a change that is going to take place in one way or another as the events evolve.
I'm impressed by one of your comments about the small town, small firm culture of a sense of a duty of a lawyer in a law firm to render legal services to all the citizens of the community. Has that culture changed over time?
I think most things of that type have changed. My memory of the local bar is on a hot summer afternoon, the lawyers would tend to gather around a telephone pole behind the courthouse and engage in general conversation, and before long there would be a group of 10 to 15 lawyers standing around talking. Now that wasn't a regular thing, but it illustrated the companionship and the collegiality of the bar. There was a unity there, and if a lawyer needed help, his brothers at the bar were anxious to give it to him, whether it was financial assistance in an emergency or whether he was in a case and he had a problem and he needed some help solving it. I don't think you find that sort of thing going on now, largely because, for one thing, it's very seldom that the lawyers are grouped around the courthouse as they were formerly. But I also think that maybe there's less regard for the need for civil and criminal assistance in cases to people who are indigent.
Well, let's move to that sense. You were one of the founders of Legal Services of North Carolina, Inc. That occurred in 1975 and 6, the movement to found this organization. Tell us about how that happened, how it came about, your role in it, and why it was so important.
Well, I think although it came to fruition in 1976, when Legal Services of North Carolina, the corporate governing body for the whole state, was organized, it had been in the process of development over a good period of time. The situation was that the bar generally was controlled by a group of reasonably affluent and successful lawyers who had a number of private clients that were important to them, and they really didn't appreciate the need for somebody who would furnish assistance to clients who could not pay for the services. There was at the same time a group of lawyers and non-lawyers who recognized that need and who had started an organized movement to get the Bar Association to promote something that would provide universal legal services. And as that movement went forward, Bill Thorpe from Rocky Mount was one of the leaders. There were a few others who joined him in proposing a study of the legal services situation in the state. And as a result, a committee was formed by the Bar Association to make that study. At the end of the study, a report was filed containing detailed findings and showing that there was a definite need for a statewide legal services program. Now, at that time, there were 3 established legal aid offices, Durham and Winston-Salem and Charlotte. There were 3 or 4 other less successful programs. This idea of establishing a statewide program to be financed by funds from the federal government and the state, as well as the localities, met with considerable opposition within the bar. And there were reasons such as we don't want to do this because these legal aid lawyers will be suing our regular clients and things of that kind. But after a rather lengthy fight, we did get it passed in 1975, and the corporation was organized in 1976. And now there are legal aid resources in every county in the state. There's an office in at least every judicial district, and there are offices in other counties as well.
How important is it to your philosophy as a lawyer, this idea of privilege, that you were instrumental, along with others, in effecting change that resulted in opening up access to the system to the poor and the indigent and those who couldn't otherwise get into the system?
Well, I think it's very important. Now, I think that the opponents have something to be said for them. They had some good points. But on the other hand, our legal system is on the surface open to everyone. But the problem is there are so many people who have the door open, but they still have to pay an admission charge to get in, and they simply do not have it. And the Legal Services Program provides public financing so that theoretically anyone who needs a lawyer and cannot afford him will be furnished with legal assistance in the form of a legal services lawyer who will be designated to represent him. Now, granted, this does not work in every case because we still have a shortage of funding. The administrations of a number of presidents have openly resisted this and have curtailed the funding that was needed. And then a more liberal administration would come along and the funding would go up only to be cut back again. It's been a long, slow process, but I think it has been successful. I think it's going to continue to grow.
I see a common thread in your character from your early experiences growing up the son of a lawyer in a small town during the Depression, through the war and the issues of discrimination and segregation and lack of access to the system, of the ability of a lawyer to effect profound change in our society and our culture. How do you see those opportunities, and what do you think are the obligations of lawyers to effect change?
Well, I think that lawyers have an obligation that perhaps extends beyond that. It's not only effecting change, but it is preserving rights and making sure that people have the opportunity to enjoy the rights to which they are entitled when they cannot enjoy those rights unless they have someone to represent them who is trained in the law and in the process through which it works, and someone who is available to them. Now, you can have all the outstanding lawyers that you want, but if the poor people don't have access to them, that is, don't have the money to pay the fee, and there's no one else to pay it, then those people simply do not have the opportunity to enjoy those rights.
Well, one of the concerns often expressed today is that lawyers are so busy and economic pressure is so great to produce, especially with young lawyers, and their debt service is so high that all they do is spend time in their office and practice law, and that they don't get involved in the broader, more important issues of affecting public policy and making sure that these great concerns and goals are met. How do you see that situation?
I recognize that things have changed in that respect. I recognize that the cost of operating a law office have increased significantly. The cost of the technology that is now used, the computerized systems have increased the cost, and therefore lawyers must have a greater income in order to meet those costs. On the other hand, I still think that lawyers have the privilege to practice a monopolistic profession, and in return for that privilege, they are obligated to pay something back. Now, it doesn't have to be in any one particular form. It can be through pro bono work representing indigent clients. It can be through participation in government activities. It can be through participation in the organized bar, civic programs of all kinds. But I think that lawyers should have an interest in something of that type and be able to sacrifice some of their time to advance that interest, even though it may diminish to some extent the income and profits that could come if they devoted their entire energy to making money.
One of the things that stands out in your career, Mr. Brinkley, is the number of times that you have participated in appeals to the highest courts of this state and in the federal court system. Tell us about, in particular, this standback case that's involved important questions of law and caused you to litigate it so hard and so long.
Well, that case was an unusual case, and I can't go into details because of confidentiality requirements, but it was an example of how our domestic law needs to be improved and adapted to the present economic and social structures. The case was fought, and it was hardly fought for, I think, about 8 or 10 years. It went to the Supreme Court 4 times and went to the Court of Appeals 3 times and had 2 full-scale trials in the Superior Court. There were a number of issues that were raised in the case, and the case created a resolution of some of those problems. We don't have too many cases like that. But as long as our legal system is designed as it is, then cases of that kind will have to be litigated in order to satisfy the demands and the requirements of the parties involved.
Particularly in a domestic case, it seems to me it's unusual that a case would last 8 years with 4 trips to the appellate level courts, and including 4 to the Supreme Court of North Carolina. What advice and lessons and conclusions do you have to young lawyers or experienced lawyers about your duty to litigate a case so hard and pursue the appellate issues so strongly?
Well, Hank, I think probably the most salient lesson from it is that in the long run, it is the wishes, the desire of your client that control. Now, in that case, normally after a period of time, there would have been a settlement, because what it involved primarily was the custody of minor children and the support of those children by the parent. But the parties in that case were not amenable to a compromise. And when I say compromise, I mean making major concessions in what they sort of set out to obtain. I have always felt that a settlement was by far the most desirable conclusion of any controversy, because I have seen very few controversies that was resolved by a trial that was as satisfactory as a settlement is. But in the Standback case, they simply did not wish to do it. And as a result, the lawyers were required by ethical considerations to fight as long as they could do it within the bounds of ethical restraints. And as a result, we tried the case, it was appealed, came back, it was tried again, and throughout there were a number of motions that were appealable, and it was incumbent upon us to go forward with those procedures as long as our client insisted that we do it.
Well, 8 years on one case must be the record for stick-to-it.
Well, you see, that one thing that affected that was it was a custody case, and motions could be made for modifications as we went along in the custody arrangement. And when you realize it takes a long time to appeal a case because of the time involved in the preparation of the record and the arguments, and then the time the court has for consideration. So it's pretty easy to use up a year or 2 on one appeal. And I grant you that was a long time, but it just turned out to be the way it was.
Mr. Brinkley, another aspect of your career that's impressive to me is the breadth of your practice, including your representation of the Davidson County School Board. Tell us about that experience and the span over which you represented the school board.
Well, that experience illustrates one of the important aspects of the legal practice now, I think. When I first started representing the Lexington City Board of Education, it was right after the law school case that I mentioned earlier, when we appealed, the Attorney General appealed that decision to the Supreme Court of the United States. Up to that point, school board representation had not amounted to very much. I think I was employed by the school board right after I returned to Lexington. The first year or so, about all I did was prepare a few deeds and examine a few real estate titles and that sort of thing. We have continued to represent them over the years, and now representation of the school board has become almost a microcosm of the entire scope of legal practice, because you have hiring problems, firing problems, you have students involved, you have parents involved, all sorts of governmental regulations in the areas of special education, and we have constant problems, not problems necessarily, but constant questions in our office coming from the Board of Education because they need so much legal advice. And as a result, that has been a significant part of our practice for the past few years.
Would you encourage young lawyers to engage in representing public bodies if they have the opportunity? Municipal governments, counties, towns,
yes,
boards?
I think so, because for one thing, it's interesting. I mean, it's a type practice that involves a lot of novel questions, a lot of important questions, and there are not too many opportunities, but there are some. And more these boards and commissions and agencies are employing their own counsel on a full-time basis. But it is a desirable part of the practice if you're in the general practice and you have an opportunity to be employed by some governmental agency.
And with regard to professionalism, I suspect that representation of a board such as a school board that brings you into contact with parents and some of the most emotionally charged issues will give you an opportunity to test your patience and understanding and grasp of the human psyche.
Yes, and that touches one area that I think is important in developing a practice of law. I think that the wider the area of experience, the more diverse the situations in which you're involved, the better lawyer you become. And one of my concerns has been for a long time that we, in the legal profession, we are leaning too much toward specialization. Now, throughout history, there has been a debate between the generalists and the specialists, and there are good arguments on both sides. But as far as lawyers are concerned, I think the generalist approach is the best. Now, that doesn't mean that you can't concentrate more in one area than you do in others. But I think there's a danger of developing sort of a tunnel vision and seeing legal problems only within the perspective of your particular specialty, when there are very few legal problems that are confined to one specific area, and the overlap is something that you need to be able to know about and to recognize and have some way of handling.
Well, now that you're into 2/3 of the 6th decade of your practice, What are the other concerns that you have about the profession as we now seem to be?
Well, one concern is that we are moving so rapidly toward the large firm concept. Now this may not be as true in smaller towns and rural areas such as Lexington, but in the larger areas, when I started practicing, you would rarely find a law firm anywhere in North Carolina with more than 4 or 5 partners. In fact, I can't think of one. Back in 1950, we'll say, it had that more than that. Now, law firms with more than 100 lawyers are certainly not uncommon. Law firms with 20 to 50 lawyers are just routine. And although that is a good thing, in my opinion, because it provides an opportunity for specialization, it's not so good when it reduces the role of the generalist and tends to sort of fragment the profession.
What about one of the other concerns you've mentioned to me is your concern over the increase of the use of the billable hour as the means for determining client fees?
I do have a concern about that. This is something that developed starting, I like to say in the north, but starting up in the northeastern part of the country in the larger cities. When I started practicing, I don't know of any lawyer in North Carolina who billed strictly on the basis of an hourly rate and developed the billable hour fee process. It gradually came in, I would say, in the 50s and 60s, and it was considered sort of a boon to lawyers. You know, if you bill on an hourly basis, your income will be increased by 50%. That was the general pitch. Now, I see the wisdom in that because it forced lawyers to be more accountable and to keep track of the way they were spending their time and to use that as one of the main criteria in fixing a fee. Because the objective, in my opinion, needs to be a fair fee for services rendered. But we have to realize that the ethical rules, I think it's, I can't remember, 1.5 or one rule of ethics, sets out 8 different factors that should be considered in determining a fee. Now, the way it's worded is you use those factors in determining whether a fee is excessive. But in truth, you should use those factors in determining the amount of the fee. And the trend has been toward neglecting all of the factors except the amount of time spent, which obviously means that lawyers with less skill and ability can be given jobs, be given tasks, and they can't do them as quickly as lawyers with more ability, and yet they are inclined to charge on the basis of the amount of time they've spent. And I think more emphasis should be given on a full and fair consideration to all of the factors rather than just the amount of time.
Do you see the billable hour as increasing the tension of lawyers to become work addicts and diminishes collegiality as an important offshoot?
Oh, I definitely do. I know there are firms that judge the performance of their lawyers on the number of billable hours they put in, which is a way of measuring the dedication of the lawyer to his task. But on the other hand, if you are going to give primary credit for the amount of time that the lawyer spends that can be charged to the client, then obviously there's going to be less time for that lawyer to devote to public service, public interest, and to other things that need to be stressed.
So you would applaud the efforts of the Bar Association and the profession as a whole to find or to address these issues that the billable hour creates in an attempt to find alternative solutions?
Yes, I definitely would.
Well, during the span, again, of this 57 years of law practice that you have entered into, what are some of the other changes you've seen, particularly with the change in the makeup of the profession?
Well, I think probably one of the main ones is the increased diversity. We have more women practicing. You know, when I was in law school, and a law school class of 120, we had 3 women. Now, law schools are, majority of the students in some places are women, which is a good development. I'm not being critical of it. I think women, on the whole, make excellent lawyers. I think there are some problems there that need to be continually addressed, such as developing a flexibility in the work schedule that will enable women to be good lawyers without sacrificing their role as wives and mothers and members of a family. We have a greatly increased ratio from a racial standpoint now, but I think, again, that has been an excellent development, and I see that continuing. There are other changes, but those are 2 of the ones that come to mind immediately.
One of the important aspects of your career is that you were selected to be president of the North Carolina Bar Association and served in that capacity from 1974 through 1975. Tell us about that service and what it has meant to you.
Well, the main thing that it has meant to me has been the development of friendships with lawyers all over the state, practicing in every field and with so many varied social and economic backgrounds. And the thing that it has convinced me of is that lawyers are about the best group of people that you can find. It's just a good group of people to have as friends. Another opportunity has been the chance to see what the state is really like and what the needs of the various localities are, and to see how many diverse elements we have in the state, but the unifying elements sort of bring us together again. I could go on with that for a long time, but those are the 2. Plus, the other thing is the professional issues we've addressed, and the main one being the development of the legal aid system that I referred to earlier. We installed a system of lawyer referral, which has been very successful over the years. And there were some other issues, such as the Supreme Court asked the Bar Association to develop a new set of rules of appellate procedure. And in the course of that study, the committee met with members of the Supreme Court and with other knowledgeable people in the appellate area, and we came out with a set of rules that was basically adopted by the court. And this brought about more interplay between the bar and the Supreme Court, which I think, in addition to providing a set of rules, it provided an opportunity for the 2 bodies to become closer.
Well, to work for these improvements in the profession, to serve in in a leadership position with the bar, to serve for years and chair the Board of Law Examiners, to serve as President of Legal Services of North Carolina, Inc., required you to give up a lot of time in your practice, and therefore required not only an economic sacrifice on your part, but that of your firm. Why do you feel it was worth it to render that service?
Well, I'll be frank with you. In the first place, it was fun because, as I said, I was dealing with interesting, enjoyable people. But the second reason is just what I have earlier said. I felt or feel that every lawyer has the obligation to contribute something for which he doesn't receive any direct compensation or remuneration. And I just elected to spend my extra time working in activities of the organized bar and in the legal aid area. Now, my partners may have felt that I spent more time than I should, but I enjoyed it, and that's my reason.
Well, one of your personal hallmarks to me as a lawyer practicing in the same judicial district as you, and having had the chance to be mentored by you and to know about your character and your reputation, is that your integrity is without question. And I'm certain that one of the reasons that's true is not only your upbringing, but the wonderful woman to whom you've been married for in excess of 50 years. Tell me about your wife, Helen.
I cannot give enough credit to Helen for tolerating a lot of my activities. She's always been very understanding, and I think some of that can be attributed to the fact that her father was a lawyer and she understood the demands of a law practice. But she has gone very far beyond what anyone would have expected and has been understanding and, as I said, tolerant, and most of all, supportive in times when I needed support. And there have been plenty of those. But there's never been a time when she didn't act as a consoling factor, an encouraging factor, and she has been a perfect mate through 56 years.
Well, you're fortunate to have her. As we come to a conclusion, I would like for you to talk a little first about the frustrations that you've had in the practice of and in the profession and with the profession, and then to talk about the sense of accomplishment and purpose, both personally and of the profession.
Well, Hank, as far as frustrations and disappointments, I suppose the main thing that occurred to me is that the same sort of thing you find in any area of life in which you're engaged in some sort of contest. In this country, we have philosophical differences, political differences, and there's a certain amount of tension involved in practically every activity in which we engage. And we have people who are extreme on one side and extreme on the other, and the rest of us fall somewhere in the middle. I'm inclined to be a little more toward the left. And there have been times when I was chagrined, disgusted, frustrated because the other side was not willing to move as fast as I was. But basically, that's something that has to be reckoned with and has to be accepted. And about all you can do is continue to work as hard as you can for the view that you think is best. Now, as far as satisfactions, I think having had a law practice with a group of excellent lawyers who made up our firm, and having had the opportunity to work with them and with other members of the local bar has been the most satisfying element of my practice. There's just nothing that can overcome or equal the satisfaction that comes from a nice, good relationship with other people.
And finally, are there any words of advice that you would give to the profession?
I think if I were going to advise particularly a young lawyer, it would be to, number one, work hard, because nothing supplies the result of hard work in preparing and in sticking by the rules and doing it the right way. On the converse, one other piece of advice was, don't overdo it. We all have to live and do the things that we enjoy doing. And there are some people who get so dedicated to the practice of law that they eliminate the opportunity for that side of life. So if you can blend those two things in the right proportions, then I think success is available and is enjoyable.
Then, Mr. Brinkley, on behalf of the Chief Justice's Commission on Professionalism, thank you for taking your time today, and on my behalf personally, thanks
Thank you
for all you've meant to me and to the profession.
Thank you. It's been my pleasure, Hank.